I know it's early for everyone, but I want to say that the person who got up the earliest was Tom Fox. He is in Texas. So it's about 7:30 in Texas right now. And I will let Cynthia introduce our special moderator because she's in New York. So, Cynthia, please.
Thanks, Isabel. Good morning, everyone. I can't believe, Belle, I think this is our 10th webinar, which is really exciting. Thank you for all of you who join us on a quarterly basis, and especially special thanks to Tom Fox, who always shares with us valuable insights on anti-corruption efforts worldwide. I'm very happy today because I get to introduce and co-moderate this event with my friend and colleague, Rachel Berk. Rachel's a forensic accountant by training, and she leads our team of forensic accountants in New York. She's worked on cases worldwide and has done some very sophisticated work involving expert testimony, fraud, corruption, money laundering investigations in the US and abroad. So thank you, Rachel, for joining us this morning.
Thank you so much. I'm delighted to be here with you all.
Thank you, Rachel. Well, so without further ado, let me, well, we don't need to introduce Tom. Tom is our star. He is the compliance evangelist. And today we have a very special topic, which is the top 10 things to do in FCPA investigations. And Tom, before you start with giving us these top 10 top things to do if you find yourself in an FCPA or any U.S. governmental investigation, can you please tell us a little about your books? Because, you know, I have some of them and I know they're available here. Yes, they're available on Amazon. But I find that these books are really my bedside table books. They're fabulous. So if we can just go bling bling and give us a little commercial here.
Sure. So the biggest and best is this one, the Compliance Handbook. Although I know I just looking at the picture, you can't see that. It's available on LexisNexis, and the 5th edition will be out later this month or early next month. If you're looking for something a little more visual and a whole lot more fun, I have a trilogy of children's books that talk about the role of a compliance professional, speaking up, culture, and the role of compliance. I think they're entitled Speaking Up is Awesome, Being a Compliance Officer is Awesome, and Compliance Saves the Galaxy. They're all about the journey of young children to a planet called Pawtastic Friends. Planet Pawtastic Friends is named for friends of mine who have a charity in dog rescue, and that's the name of their charity. So all of the profits of those books go to their charity, but it also will teach anyone literally from age 3 to 83 about compliance. A lot of people use them to tell their parents what they do in addition to their children. So, but the book we're going to talk about today is called the FCPA Survival Guide. And I've provided the link to Isabel and Cynthia. It's available on Amazon. It's only $10, so it's relatively inexpensive. And the reason I wrote this book is starting in December of 2022, we started getting some significant information from the Department of Justice in the DPAs and NPAs that concluded FCPA enforcement actions. And there were 4 key ones I wrote about near the end of my writing. A 5th one came out. So I was able to put a few words in on that as well. Or rather, there were 3 and then a 4th came out. So the cases were ABB, Albemarle, and SAP. The Gunvor case came out just as I was concluding the book. So I put in a few words about Gunvor. But what the DOJ did for us in these 4 cases is lay out what you can do to get the best result for your client if you find yourself in an investigation. And I'm a big believer in top 10 lists. So I figured out the top 10 things you should do. And that's what the FCPA survival guide is. It's the top 10. It explains in detail what each one of them are. And then I summarize in detail each one of the cases, ABB, Albemarle, SAP, and then Gunvor. So you've got the cases if you want to go in that direction, if you're a lawyer or just interested in the facts of each one of those cases.
Forgive me for interrupting you. I don't see the window where the interpreter is. Tatiana is the interpreter. And Caroline or Tatiana?
No, it's now problem is in connection.
So we don't have an interpreter?
No.
Okay, thank you, Tatiana. I apologize to everyone. That's why we were delayed, as a matter of fact. So today, we're all fluent in English, right? And I just want to remind everyone that we do have the chat box, the questions and answers box where you then will be able to ask your questions. That is not a problem. If you write a question in Portuguese, just remember to leave your name and the organization you're with, and then Cynthia and I will definitely help with the translation. Tom, forgive me for the interruption, but I think that was very important. So we don't, although I know that the interpreter was here with us, we haven't been able to set up the window for him to be doing his job. Okay, sorry, Tom.
Not a problem. So I will try to translate my Texan into English. Hopefully it'll work. But so there are 10 things you can do, and they are things that are going to be familiar to every compliance officer. They are things that are going to be familiar to people like Isabel who have experience in negotiating with the Department of Justice. They're going to be things that Cynthia and Rachel are very familiar with because they're going to speak directly to what they do with data analytics, internal controls, and a wide variety of other areas that really non-lawyers can focus more on than the lawyers who might be on this call. So there's a role for everyone in this. And if you use these strategies and you use these tactics, you can significantly reduce your potential exposure. You can reduce it all the way to zero. That's called a declination. But under the FCPA, or now it's called corporate enforcement policy, you can get a 75% discount, and that's real dollars. So what are the top 10? Number one, the most important that was discussed in every enforcement action is self-disclosure. It all starts with self-disclosure. You must self-disclose to get the benefits, all of the majority of the benefits. You can still get some without self-disclosure, but the DOJ made very clear they want self-disclosure. The next one, and this one's going to perk up the ears of Isabella because it did for me as well, and that's the need for speed. And that's a phrase that comes to us directly from the DOJ. And the need for speed is the DOJ wants real-time reporting when you're doing an interview or document review. So I'd like you to think about that for a minute. Tom Fox Energy Company hires Isabel to do an investigation. She is interviewing witness, and what the DOJ says is pick up the phone and call us. Call us when you're finished. Don't call your client, call us. Well, that's very difficult for a lawyer to do. And it's very difficult for an outside counsel to do. And it's very difficult because the team back in the corporate office really doesn't have time to digest that information and really figure out how does this fit into the larger picture? Does it impact our strategy in terms of remediation? You know, what are the implications? But the DOJ expects a company to share information with regulators as quickly as it finds out those facts. Now, what the DOJ says is that is not cooperation. That's not excellent or superior cooperation. That's extraordinary cooperation. And how do they define extraordinary cooperation? They know it when they see it. Yeah, that's the definition of extraordinary cooperation. So there's a very famous legal case in the United States from the 1970s around pornography, and the justice who wrote the opinion said, "I know it when I see it." And so that's a big joke in America. Well, that's what the DOJ has said about this extraordinary cooperation. I cannot tell you, does that mean Isabel picks up the phone from the interview? Does she pick up the phone after she calls me? Does she pick up the phone after she goes back to her office and thinks about the information? I can't tell you the answer to that because the DOJ hasn't told us. All they've told us is extraordinary cooperation gets you big benefits. Now, for all of the compliance professionals on the phone, particularly in-house, the next one will be very familiar: extensive remediation. That's what we do. If there is a violation of the Brazilian Clean Companies Act, of the US FCPA, of the UK Bribery Act, of French sapon-du, then that means you've had a failure of your compliance program. So the DOJ expects extensive remediation, but it's not just remediate. You have to document what you've done, and then you have to test with data analytics to show everything you've done. Next up, number 4, root cause analysis, risk assessment, and gap analysis of internal controls. Each one of these has a little bit different focus, so you can't just put them all, I put them into one category, but each is a little different. A root cause analysis is basically you keep asking the question why until you get the answer. So why did the system fail? Why did the person do what they did? That sort of thing. A risk assessment is just that. You assess your risks. Whenever you did your risk assessment the last time, your risk would change. And then a gap analysis. A gap analysis is an analysis of your internal controls to determine if there are any gaps. So root cause analysis, risk assessment, and gap analysis of internal controls. Number 5, data analytics. You should implement a data analytics program across your entire company. In the Albemarle FCPA enforcement action and in the SAP enforcement action, the Department of Justice called out both of those companies for instituting data analytics programs. Now, there's no one data analytics program to fit all. It is tailored to your company. But that is something that is moved from cutting edge. Now it's best practices. In 2025, it may just be regular, table stakes, but you have to have a data analytics program. Now let's turn to incentives and consequences, or what I would have called incentives and discipline. Well, it's now called incentives and consequences. So do you have incentives in place for people to do business ethically and in compliance? And by that I mean financial incentives like a bonus program or something like that. But equally importantly are the consequences. For those who received a bonus based upon their illegal actions to pay bribes to get a contract, did you claw back or hold back those bonuses? For senior management who may have turned a blind eye or looked the other way, did you claw back or hold back? Now, I'm not as familiar with Brazilian labor law as I am with labor law in the great state of Texas or other states in the United States. But once you pay somebody, it's very difficult to get that money back. And if someone's paid a salary, you basically can never get that back, period. Now, if it's a discretionary bonus or stocks, perhaps you can get that back. But SAP particularly went after senior execs who allowed this conduct to happen, and the DOJ called that out specifically. Number 7, This is something new that we had not seen before, and that's the change in sales models. Both Albemarle and SAP had extensive use of third-party distributors and third-party agents and third parties to generate business. Albemarle dealt completely away with third parties. They went to a direct sales model only. Now, there are risks when you have a direct sales model, and they're different than third parties. But that is something that the DOJ called out specifically. SAP did away with third parties as business generators. They still have distributors, so there's a risk there, but they did away with third parties for business generation. Next up, enhancement of compliance. This is a little bit different than remediation, because here the DOJ is focusing on the corporate compliance function itself. So typically that means did the company bring in a top compliance professional to either be the CCO or to be a subject matter expert for the compliance function? What about the people in the compliance function? Did they get additional training? Were they certified in it by the SECE or any other group that certifies compliance? So headcount, meaning did the number of people in the compliance function increase? And what about budgeting and resources? Did the compliance function get the money it needed to move forward? Next up, internal controls. Several companies of the companies I've named enhanced their internal controls. It started with a gap analysis, but they put special emphasis on internal controls in addition to all the other remediation. And finally, your investigative procedure or protocol. And here the DOJ focused on, they really tied it back to number one, this need for self-disclosure. And the self-disclosure comes because once an issue is identified in your organization, whether that identification is by a whistleblower, someone who stands up and speaks up, whether internal controls picked it up, however it may have come about, you triaged it quickly and you were able to get enough information to know we've got a problem here and we need to self-disclose. The gold standard for self-disclosure is not any of the four cases I've talked about so far. It's a case called Cognizant Technologies. And in that case, the board of directors self-disclosed to the DOJ 2 weeks after being informed. And they had literally CEO and chief legal officer direct involvement in the bribery and corruption. So you had bribery and corruption at the highest levels of the company, but Cognizant Technologies, because they self-disclosed and did all these other things, was given a complete declination, no fine or penalty. So it can be a very powerful tool if you can get the information intake, and then triage it and do a quick and expeditious investigation to see if you have a real problem. So those are the top 10. I know I rolled through those pretty quickly. Isabel, I can email you kind of the one sheet with those so you can circulate that to the group or translate it as appropriate. And hopefully you'll buy the whole book.
Yes, of course. Thank you so much, Tom. We'll send to everyone the one sheet. I took notes here. I'm a little scared, but I am going to have Rachel moderate this group. And again, if you have any questions, please put your questions, whether in English or Portuguese, in the Q&R box, and Rachel will pick up the questions, combine them, or adjust them as she feels is the best way to put the question to Tom. Rachel?
Yes, thank you. Tom, thanks so much. That was really interesting. While I wait for some questions to come in, I had some of my own as I was listening to you and thinking about your top 10 list. I know you said the first point is the most important about self-disclosure, but if we take a step back, how should we all be thinking about, how do you rank all these items in the list? I know you said self-disclose is important, but should a company be, was this, are the rest in order of priority, or should a company be trying to achieve as many of these top 10 points as possible?
So I put these in, I took a little bit of editorial liberty. Self-disclosure is clearly number one. Each one of the enforcement actions talked about self-disclosure, and they talked about it even if the company didn't self-disclose, because what the DOJ said was if they had self-disclosed, they would have gotten additional discounts. So sometimes you communicate information by talking about it. Sometimes you communicate information by talking about things that are not present, and that's what happened in these. So I'm very comfortable, and we've actually had about 5 speeches where the DOJ says it all starts with self-disclosure. So that's clearly number one. Everything, every discount available turns on whether you self-disclose or not. The need for speed, the rest of these come literally from speeches the DOJ has given, which sort of fills out or gives us additional information about what was in the DPAs and NPAs. So the need for speed is something that was called out in the ABB enforcement action. And why it's so significant is the following. ABB was the first 3-time FCPA violator. So in 2000, in 2006, and or 2007, and now 2018. So all of us expected ABB literally to be hammered. ABB did not meet the criteria for self-disclosure, but what they did do was have this real-time reporting. Now they did the rest of these steps too, and ABB got an incredible discount, particularly considering they were the first 3-time loser. So you can get real discounts if you have that extraordinary double secret cooperation that none of us can figure out what the definition is. The rest of these came from the actual enforcement actions themselves. So there were things that were called out in each DPA or NPA. What the DOJ does not say, you put in a data analytics program, you got a 10% discount. It's always a series of actions by the company which lead to the overall discount.
Okay, thank you. That's helpful. I just want to pick up on something you said, but it might be a clarification point. I think you had just said that for ABB, they did not meet the criteria for self-disclosure. So I was wondering if you could share a little bit about what that criteria is, as well as if it relates to any sort of timing criteria, because I understand that the DOJ have recently released some initiatives that reward self-disclosure within, let's say, 6 months of discovering a violation. Is that in play here too?
So what the DOJ says is you must self-disclose, but that self-disclosure must be timely. Well, let's work through that together. What is self-disclosure? Self-disclosure is when you tell the DOJ, we believe we have an FCPA violation before that information is put into the public arena. So here's what happened to the ABB. ABB literally picked up the phone and called the Department of Justice and said, we want to have a meeting. And they'd scheduled a meeting, I think 3 days after the phone call. Between the time of that phone call and the scheduled meeting, the South African press broke the story of the bribery and corruption of ABB in South Africa. So under the DOJ's interpretation, they did not self-disclose because they did not call and self-disclose a FCPA violation. They only called to set up a meeting. So for those of you in-house, or those of you like Isabel, if you're going to pick up the phone and call the DOJ, you better say, we want to meet about a self-disclosure and an FCPA violation. But the significance was the DOJ spent a large part of the DPA detailing that list of facts that I just gave you. And they were clearly impressed by ABB's attempt to self-disclose. Now, they didn't get self-disclosure credit, but what it did, or they didn't, get monetary credit in the form of a discount, but what it bought was credibility of ABB to the Department of Justice to fix the problem. Now, all of the other things ABB did added to that credibility, which led to the superior result from ABB. But we know you have to self-disclose the FCPA violation to get that discount credit. But even if you miss it and you've done like ABB did, tried to do it, or set up an appointment to do it, and you do these other items, you're going to get significant discount from the DOJ. Now let's move to point 2 you raised, Rachel, which is the timeliness of your self-disclosure. Albemarle self-disclosed to the Department of Justice, but they self-disclosed 18 months after they started their internal investigation. And so the DOJ said, that's not timely. Now, they have, because the DOJ said, if you self-disclose, you're eligible for a discount. Albemarle moved into the eligible for a discount, but they didn't get the full discount, and they didn't get the full discount because it wasn't timely. So you have to self-disclose, and it has to be timely. Those timelines you mentioned, Rachel, have not yet been formally put in place by the Department of Justice. What I would tell you is the DOJ has announced an internal whistleblower program for itself, as opposed to the Securities and Exchange Commission under Dodd-Frank. And the reality is those timelines are going to be put in place, and they're actually maybe even quicker, because if someone can self-disclose to the Department of Justice and be eligible for a financial reward, whether they tell the company about it or not, they'll probably run to the DOJ if the company doesn't do anything or appear to do anything.
Okay, thank you. That's very helpful. I do want to turn to a question from one of our participants here, from Rodrigo Moreno. Has there been actual cases of the clawbacks that you mentioned and the holding back of the bonuses? And perhaps you can share, if so, a little bit about that circumstance and maybe what happened in the SAP case.
Sure. So SAP is the one that the DOJ wrote the most extensive about. Although in the Gunvor case, there were clawbacks. In a more recent case called Trafigura, at least I call it Trafigura, there was also clawbacks. So what the DOJ wants to see is what I've outlined, that if people received monies, discretionary bonus, stock awards, something beyond their salary because of their bribery and corruption, or because of their corrupt activities, you as a company have to try and either claw that money back, that's the clawback, or hold that money back, which could be a discretionary bonus. Now, to get a holdback, that means you have to have, pretty quick discovery of the issue and investigation. In SAP, there were numerous court actions that SAP engaged in to claw money back, and the DOJ has put together a financial incentive for this, and they will give you a dollar-for-dollar credit for every dollar you claw back or hold back for people who've been involved in an enforcement action. And they've created a pilot program to test this, starting with SAP, but so it's been in place since January, I think. But the significance is you get a dollar-for-dollar credit for every dollar you claw back or hold back. SAP went to court to get a lot of these back. So you may have to file a court case, and that's where the law of every jurisdiction is going to apply. It's going to be different in America than it is in Brazil, than it is in Kazakhstan, or, you name the country. But the DOJ will give you credit if you at least try to do so.
And besides that one-for-one credit that you just mentioned, is there some other benchmark or assessment that a company can make to determine what would be sufficient in considering some sort of financially, what the amount would be to determine what the holdback or clawback would or could be.
Well, if it's a clawback, it's the amount you paid out. If it's a holdback, it's what they were eligible for. So in my last corporate position, everyone was eligible for a discretionary bonus, depending on the profitability of the company. If I had engaged in bribery and corruption, the DOJ probably would have said, okay, some or all of Tom Fox's discretionary bonus should be held back or clawed back, whatever that might be. And it's a lot easier when compensation is commission-based or something along those lines. But you have to make some calculation. Right now, no one's made a wrong calculation on that. And I think it's because the program's so new and we don't have any greater specificity in the guidelines as yet.
Okay, thank you. That's helpful. In thinking about the need for speed, and I don't mean to press on this, and I know you gave some examples, but I thought that was so interesting, the part that you were talking about, the know it when you see it. And with respect to this extraordinary cooperation concept, and I know you gave us an example earlier about, getting out of an interview and immediately picking up the phone and reporting that to the regulators. Are there other examples that have been documented or that, we can just think of that companies should be thinking about that would lend itself to this term of extraordinary cooperation?
The short answer is no. There are no other documented examples. What we do have is the speech by former Assistant Attorney General Kenneth Polite, where he announced this need for speed. And he literally said, the DOJ knows it when it sees it. And that was it. And it's not regular. Go back to the office and call. It's the SEC said ABB engaged in real-time reporting. So that's the only written language or written evidence we have from either the DOJ or SEC. Couple that with Kenneth Polite saying we know it when we see it. It's for those who may have gone to college in the United States, it's sort of like double secret probation. You don't know it exists and you don't know what the rules are.
Right. If I may, Rachel, because
Yes, please.
That's precisely the point that really got me scared. Because as you know, in all investigations that we have, we work 24/7, and we obviously we're interviewing someone and we go back to the client immediately and saying, this is what's going on, and therefore I will need to speak with someone else. This other person suggested that I speak with X or Z. And there's a lot of strategy being worked on in real time. But that's obviously between the client and counsel, and there's no room for DOJ. Are you kidding me?
I'm completely with you.
I know, but has there been any real case where there was? I have some notes here, but I understood that there's full cooperation. There's all different types of corporations that you get full credit. But has there been a case where the DOJ was satisfied that real-time cooperation happened?
SAP. No,
SAP.
I'm sorry. ABB. And ABB in the SEC enforcement action, that's where it said that ABB had engaged in real-time reporting from their investigations. And that's the most definitive statement we have.
Right. Definitely. This is one to watch for. And Rachel, do we have any other questions, or maybe yes, we do. So I don't want to. So I don't want to interrupt here, but if there's no other question, Rachel, I have about 10. Okay.
Oh, okay. I think we have a couple more. I see one just came in from Tiago, from CRA. If you could, Tom, please elaborate on the different sales models that you had mentioned. We had talked about, we heard you say direct versus third party. and what the DOJ considerations were when evaluating these different models from a risk perspective, from an FCPA perspective, et cetera.
Sure. So you can have in sales, direct or indirect. Direct is your employee selling. So at Tom Fox Energy, I have Rachel who goes out and sells, and she gets compensated based on an agreed upon salary and a discretionary bonus. That bonus can be based on how much she sold. It can be based on company profitability. It can be based on a variety of other factors. A third party typically is compensated. A third party sales agent is typically compensated on a commission basis. Generally now between hopefully 5 to 10%, it could go higher, but you're going to get in trouble if you do. And it could be much lower. It could be a third party sales agent. It could be a distributor who takes title and loss of risk and then resells. It could be just a straight reseller. It could be someone, a third party who brings leads to your organization. So Rachel might call me up and say, Tom, I think there's a market available for you in these places. Go forth and prosper. I get 3% of whatever you generate. What the DOJ has said was that in both SAP and Albemarle, the corruption revolved around or involved third parties. And because the corruption involved third parties, it was appropriate for those companies to look at changing their sales model. This did not come from the DOJ saying do it. This came from the companies making their own decision based upon their own root cause analysis and risk assessment and presenting this information to the Department of Justice. And that's a really important lesson on how things evolve in FCPA enforcement. A company makes the decision that based on our risk assessment, we're going to do away with third-party commission sales agents, and we're going to go to a direct sales model. Well, if we get 3 or 4 more of these, people may begin to think, gosh, I guess we better fire all our third-party agents. Now, there are risks with a direct sales model as well, gifts and entertainment, travel, anything along those lines. But there's actually a business reason to do away with third parties. And the former chief compliance officer at an energy company in Houston would literally preach to the business folks the following. If you have a third party sales agent, you have someone between you and your end using customer. If you have a direct sales to that end using customer, you have a direct relationship with that customer. And you always want to have a direct relationship with your customers. So when the business folks would say, well, we can't live without third party agents, he would say, why not? Why don't you go have a direct relationship with the customer? You'll have a stronger relationship with the customer. You'll probably have a better commercial relationship. And if you do your job right, you'll probably engender trust with the customer, which will lead to, a more fulsome commercial relationship down the road. So there's a real business reason for doing it, but understand there are risks in a direct sales model or a non-third party model.
Yeah, thank you for that. That makes sense. I think there's a lot to think about there. One thing I wanted to touch on, and I know there may be some other questions, but I think I wanted to touch on data analytics because there's been so much focus on it, in recent years. It's completely changed the way, as a forensic accountant, I would conduct an investigation, and I rely quite heavily on data analytics for many purposes. And so, I know one of your points was to implement a data analytics program across the entire organization, tailored to your organization. And I was wondering if you could share any insight here about perhaps what the benchmark is or how companies should be thinking about this type of holistic program, certainly because, the regulators themselves are relying on their own data analytics more heavily than they ever have before. And it's important for companies to, also be able to keep up and get ahead of the curve there.
Let me start with that last point you raised, Rachel, because that's perhaps the most significant. The Department of Justice within the fraud section has hired literally America's top corporate data analytics expert from a company called ABB, which I know, AB InBev, which I know you guys all know, a guy named Matt Galvin, and he put together one of the first, and he started with one issue, which was the cost of his investigations, and expanded it out to company-wide. So a couple of years ago, the DOJ hired him to evaluate companies' data analytics programs, number one, but equally important, to create a data analytics program for the Department of Justice so that they can do their own data mining. That's meaning they've got somebody who knows more than most people looking over your program. That said, the DOJ, you don't have to do everything at once, even if you're in the middle of an enforcement action. What the DOJ expects is a plan in place and you executing on that plan. So you don't have to go put a data analytics program in for the whole organization. Start with your highest risk and put a data analytics program in for that. The first question the DOJ is going to ask is the question they posed in the 2020 Evaluation of Corporate Compliance Programs update, which is, does compliance have access or visibility into data across the organization? Every organization has data silos or data lakes. Since 2020, the chief compliance officer or the compliance function is tasked with having visibility into that data. So what I would suggest is you start with what were the risks or what were the failures of your compliance program. Let's just take third-party agents. Put all your third-party agents in, look at the percentage commission paid, the actual amount paid, were contracts in place, all of the things that probably many of us have done manually. You can now do that across your organization through a data analytics program. You can look at all of your GTE spend. You can look at all of your marketing spend, charitable donation spend. Any place, remember, bribery and corruption requires a pot of money to pay a bribe. So where could a pot of money be hidden in your organization? Could it be hidden in gifts, travel, and entertainment? Could it be hidden in charitable donations? Could it be hidden in in marketing? All of those are places we've had FCPA enforcement actions. Gunvor was really interesting for the following reason. There were multiple executives in on the bribery scheme, and they used their Singapore subsidiary to get the pot of money to pay bribes in Brazil, meaning the Singapore subsidiary hired fraudulent third-party agents, paid them, and then took the third-party agents routed that money to offshore banks to pay Petrobras officials. That's a pretty sophisticated program. And if you're a compliance officer, you might have visibility into Brazil, you might have visibility into Singapore, but you might not have visibility into both. So I would start with whatever your highest risks are to look at, are there any anomalies? There's no benchmark that I can point you to, the DOJ has said, but just set your own benchmark based upon your own risk parameters. Low A, high Z. Anything below A or above Z should be set aside for additional investigation. You're looking for patterns in raked leaves. If you see something anomalous, that's where you start.
Okay, great. Thank you. I do see that we have another question from a participant, from Ricardo Limos. Does the DOJ look into the corporate compliance culture for an organization? And if so, how would that come into play when assessing compliance or mitigating any potential risks or fines that may come into play?
Starting in October of 2021, the Department of Justice said culture is paramount, and we will assess your culture, not simply your compliance culture, but your organizational culture. That means, separate and apart from these 10 items I've given you, you need to do a culture assessment. You need to put a cultural assessment mitigation program in place, train on that, monitor the results, and improve as appropriate. and you need to have that documented so that you can show the Department of Justice that. So far, what they've looked at is prior bad acts. So with SAP, we knew what those prior bad, ABB rather, we knew what those prior bad acts were. The Trafigura case, the Swiss trading company, they had multiple, and when I say bad acts, I mean fines and penalties that are in the public record. So that's what they're looking at now. But my sense is, my gut tells me the next step is companies who put forward, here's our culture, here's how we're working to improve it. And the DOJ says, oh, well, we're going to add that to our list because that impresses us.
Thanks, Tom. I have a question regarding ABB. So you said that they were a 3-time offender, correct?
Right.
Do you think that this demonstrates just a lack? What do you think that says about the FCPA itself? I know that there aren't many or any tried cases. So is this exactly what the government wants, for companies to consistently self-disclose, therefore they're being effective in enforcing FCPA actions? Or do you think it's a demonstration that the law is perhaps not being effective?
I think it's a couple of different things. So let me talk about ABB directly. And I know this because I interviewed the chief compliance officer. She was a colleague in Houston, Natalia Shaheda, and she was hired to get them through this. And she said when she was hired, they told her, this is not who we are, except this is who we are. But this is our 3rd violation. We don't want to be known as the company that bribes. Even Siemens in 2008, when they had one of the most extensive, other than Odebrecht, probably the most extensive program for bribery and corruption we've ever seen. Siemens employees did not want to be known as the company that pays bribes. And ABB did not want that. And so they said, what have we done wrong? What are we doing wrong? And we are going to change our culture. Now, they were highly incentivized because they knew a big fine and penalty was coming down the road and they could reduce that. But from the Department of Justice perspective, what they want to do is reduce the instances of bribery and corruption worldwide. And by companies self-disclosing, and then the publicity around but the publicity around an enforcement action. And in ABB's case, they've been very open in talking about their failures and what they've done to try to remediate the situation, from culture to controls to data analytics to policies and procedures and everything else in between. So, of course, they're not talking about companies' trade secrets or those sorts of things, but that's the dialogue the DOJ wants. They want us, everyone on this call, talking about these cases, because every time we talk about one of these enforcement actions, someone's going to learn something and someone's going to say, oh, maybe I should look at that, or maybe I need to pick up the phone and call Rachel about a data analytics program, or any of the other things we've talked about.
And Tom, have you seen trends regarding sectors the government's looking at, or jurisdictions? I remember in the past, there would be announcements.
Yeah. Industry sweeps.
Yes. Isabel has correctly denoted the technical term for that. Industry sweeps. It started with energy.
Because
that's what I was a part of.
Right? There were
Right.
instruments everywhere. Sorry.
So over the past 15 to 18 months, it's been trading companies. That ended with Gunvor and Trafigura. It started with Glencore last year, or last summer, I think, maybe 2 summers ago. 2 summers ago. So yes, absolutely, they sweep through industries. They've swept through energy. They've swept through tech. They've swept through healthcare. Currently, they're sweeping through trading companies. There'll be another industry that they sweep through. And the reason they sweep through these industries is, I know what happened in energy, so I'll use that as an example. The first big energy case was a shipping company in Switzerland, and they got the bribe. They were paying bribes to get equipment into Nigeria, and one of the Department of Justice said, well, let's see your customer list. And they got the customer list, And they said, well, if they're paying bribes on behalf of one company, maybe they're doing it for others. And of course they were. So that's what led to the sweep in energy. And what it taught me is the DOJ figures out who is the key. And once they figure out who the key is, then they just sweep through that industry. And then they did the same in tech, as I said, healthcare, and now trading.
Jurisdictions, do you see any trends there?
Really no trends in jurisdictions. It's sort of the usual suspects. Unfortunately, I have to say Brazil, but that's legacy. But here in 2024, we're still talking about Petrobras. We're still talking about Lava Jato. We're still talking about Odebrecht. So we're going to be talking about these jurisdictions for a while, but it's, you know, the usual places. It's West Africa, it's Central Asia, it's China, it's the Far East. So those, South Africa, those places are heightened risks of corruption.
Bill, right. Rachel, do you have any other questions? Because we are usually very punctual here, although we had many glitches here with Teams today.
No, I don't see any other questions from the participants. And I know we are coming close to our time.
Right. So I think that I just wanted to ask a question. I know we have only 3 minutes, but this is important here for Brazil, especially, Tom. And I think number 8 of your points, the things to do, was enhancement of the compliance program. If you can elaborate, because we're having the same sort of a thing going on in Brazil.
So let's start with the fun one. Is compliance compensated at an appropriate level? And I say fun because everybody wants more money. And is compliance compensated commensurate with the chief legal officer or the general counsel's office or the lawyers? So it's individual salaries. It is the quality of your compliance team. Is it truly a compliance professional, or is it somebody they sent from HR? But it's resources, it's headcount. Do you have enough people to get you through this FCPA journey? Typically, at least during the journey, you do, because everyone is aware within the organization, we've got to get this taken care of. So it's headcount, it's resources, it's, like I said, picking up the phone and calling Rachel and say, hey, I need some data analytics help. It's having that type of program. But a lot of it is the spade work that we do every day. It's policies and procedure. It's training on policies and procedure. It's putting together an effective communications strategy for your overall compliance. It's looking at things like, do we have financial incentives in place for people to do business ethically and in compliance? It is, are we consistent with our discipline? Are we consistent with our investigations? So it's both some new items and some new strategies, but it's also the basics.
Very good. I got very curious now. I'm sure that the whole audience here would like to hear this from you. In the States, and you mentioned the head of the general counsel and the chief compliance officer. How are the salaries in the States? Who gets the most?
General counsel.
Still. And
Still.
is it by a big difference?
I would say the difference is decreasing. And typically in companies that the salaries are close together, it's where the chief compliance officer may have other responsibilities such as sustainability, such as ESG, it may be trade compliance or export control sanctions, in addition to anti-bribery, anti-corruption compliance, those sorts of things.
Good. Thank you. That was part of the fun item that you mentioned, because here in Brazil, compliance officers complain a lot that the general counsels make, a lot more. Anyway, the DOJ should concentrate on that also, don't you think?
I'll pass that along.
Yes, please say they have to have a speech or writings to say, compliance officer should get the same amount as the general counsel. I'm just kidding. Anyway, with that, I have to thank Rachel first, our special invitation that we had for her. Thank you, my partner Cynthia, as always. The next Breakfast with Tom Fox is on Wednesday, August the 21st. I know it's far away, but I always like to have the set agenda so that we are not kind of caught in any holidays or anything. So it's after our July vacations here, which is not exactly the summer, it's the winter here, but it's a full month of vacation here. So thank you very much. Don't forget Tom's books that are on LexisNexis, and we will send everyone who participated the sheet list that Tom mentioned with the 10 points in both Portuguese and English. Thank you.
Thanks,
Thanks,
everyone.
everyone.
Thank you so
Thanks, Tom.
much.